Hi, Griffin Bridges here. This is a new format I'm testing out where I'll do occasional video updates, kind of a walk and talk type of analysis. But to start out today, I recently read a very interesting case that just came out of the Michigan Court of Appeals. And if you deal with divorce issues in estate planning, this is going to be very important to what you do because it has some very interesting outcomes, to say the least. So long story short, whenever you get divorced or start the divorce process, the court usually issues a status quo order, which keeps you from transferring or otherwise encumbering marital assets, because the idea is that they don't want spouses to start hiding assets and keeping those from being distributed once the divorce is finalized. So in this case, husband and wife were divorcing, and husband was on a second marriage, and he had an existing revocable trust that provided for now soon-to-be ex-wife. And as part of this, husband got a cancer diagnosis in the middle of the divorce. They never reached an agreement on the ultimate property settlement, which was going to be 50-50 generally, but for a dispute over a life insurance beneficiary designation. But while all this was pending, husband went and amended his revocable trust to provide that everything would go to his son, effectively disinheriting his spouse in anticipation of the divorce. But before the divorce settlement could be reached and before it was finalized, there was no decree ever issued. Husband died, and ultimately wife was disinherited under the trust. And the wife sued, and the son was issued summary judgment at the trial court level. And on appeal, wife was arguing that, one, there should be a constructive trust or reformation of the husband's revocable trust because, as a matter of public policy, the trust acted to really disinherit her from the one half of the marital assets she would have otherwise received. She also argued that husband owed her a fiduciary duty, and because of the breach of that fiduciary duty, that was another justification for that equitable relief. And ultimately, the appeals court agreed and upheld the summary judgment that was given to the son and said, one, there is no public policy reason for doing this because husband fulfilled obligations he might have had to, one, run this by counsel first, because before changing his revocable trust, he went to his attorney and said, hey, under this status quo order, is everything okay? And I think what was interesting here is that this was a case being heard in Michigan, but the divorce proceeding was actually in Missouri. Whether that had any weight in the outcome, the opinion isn't very clear. But either way, that's one thing to keep in mind when you think about how broad an effect this ruling might have. But ultimately, court concluded, one, there's no public policy reason that husband did this with permission of counsel, still intended to provide all marital assets to wife, but for his intervening death, she would have, if they settled everything out, gotten half of the marital assets that instead passed to son under the revocable trust. On the argument of whether the husband owed a fiduciary duty, interestingly, the court said no, that even when it's one spouse who handles all the finances and even takes care of the estate planning, that they owe no fiduciary duty to the other spouse. And even in this scenario where the marital assets were in the revocable trust, the Michigan court cited a rule that's consistent in a lot of trust code jurisdictions that says while a trust is revocable, the settlor of that trust owes no duty to the trust beneficiaries. And that was definitely the outcome here. So effectively, by dying before the divorce was finalized, husband was able, in this case, to change his estate plan to effectively disinherit wife. Now, to avoid full disinheritance, most states have either community property or the elective share. And Michigan happens to be an elective share state, and the opinion was clear that the wife in this case did get her elective share. So that was an interesting outcome, and while possibly inequitable, it showed how effectively divorce can be planned around in the estate planning process, and how you should note the ultimate effect, especially in a blended marriage, of an incomplete divorce at the time of death. That's all I've got today. Take care. I hope you enjoyed this episode. If you would like to take your education to the next level with exclusive article series, webinars, one-on-one office hours, and more, please consider a paid subscription to State of Estates. For $30 a month or $300 per year, you can receive education that is higher quality and higher convenience than is provided by most bar associations, CLE providers, and professional programs. To subscribe, please visit griffinbridgers.substack.com. And if you'd like to supplement this content, you can also watch or listen to my YouTube channel. Just search @Griffin Bridgers. Thank you again for listening.